the most common questions that we get asked when people are contacting us about quieting title is how long, how much, will this get done? And the answer is usually a pretty simple answer to all three of those questions. But unfortunately, there are so many factors that can dictate the length of time in the process. And I get asked to go into great detail and explain the process. So we're going to make this video specifically on addressing the questions of how long, how much, what to expect through the process. A quiet title action is a lawsuit. It is not a review of a Freedom of Information Act file. It is an actual lawsuit. And the reason that the time frame associated with a quiet title action is so important to answering the questions that are posed to us every day is that in every quiet title action, it's different. The fact pattern is different. The history on the chain of title is different. For example, is there one defendant or are there 30 defendants? Is there one defendant who is a business entity that'll be quite simple to remove? Or on the other hand, are the people dead and we have to deal with probate estates? Or an individual that's alive and we have to publish? These are huge factors that can dictate the length of time in the process. And I'm holding up here a timeline that you can't see at the moment, but will be available through my website. I'm happy to send it to anyone that contacts us. And it specifically addresses the time frame associated with most quiet title lawsuits that are filed. So let's walk our way through it. The first thing that happens is that I, as an attorney, review the title history. Now that title history may come from a title search that has been done by a title company, or they may provide me with all the deeds that make up the chain of title. But we're going to do our own title search, even if we get that title search from a title company. And I'm going to build essentially a chain. We've talked about this in many videos. Person A to person B to C to D to E to F and so on. And we're going to look at the totality of how those deeds stack up. Where are there defects? Where are there gaps in the chain of title? Gaps such that we need to get a court order to correct or quiet, and that's why it's called a quiet title action, to correct or quiet the interest. Once we built out that chain, we're then going to identify all the potential defendants. Those defendants are going to be people or entities that have undischarged interests. Interests that are affecting the quality of the title. Interests that are affecting your ability to get title insurance or your ability to sell the property. Or maybe it's an interest that's a lien holder, like a mortgage, or a claim of lien that has been filed on title. And what we do is we cast a wide net. We want our net to be wide enough such that all the potential interests are going to be cleaned. Our quiet title action is only as good as the net that we cast. So for example, if we miss one fish in that net that we're casting, the title is not going to be resolved through a judgment to quiet title. We're going to have that one fish, that one defendant that has been left and that needs to then start the process all over again to get rid of that one. So we cast a wide net to identify all potential claimants that are in that chain of title that are causing a defect or a problem with title. And then we build a lawsuit and we name any of those defendants in that lawsuit. And we build the lawsuit and it gets filed in the circuit court in which the property resides. So for example, if the property sits in Detroit, my shirt, that would be filed in Wayne County. A lawsuit is filed, filing fees are paid, and then we begin service of process. And service of process is a legal word that basically means how are we going to give notice to these owners, to these interests that must be discharged or terminated from the chain of title. And due process, our Constitution, both state and our United States Constitution, as well as our court rules, dictate exactly how you have to give notice of a lawsuit. And you've seen it many times. Process server goes out and serves somebody. It says, you've been served. Or there are other ways you can serve people. For example, we can use certified mail. There may be a court order that allows us to publish by what we call alternate means. So for example, an individual who is missing long gone. We can't find them. We can't serve them personally. We may go get a court order that allows us to serve by alternate means, which would include potentially publishing in the legal news, as well as mailing to last known addresses, and attempting in various ways to give notice of the lawsuit to the people that we can't find. Anybody that we can personally serve, we're going to personally serve. Now, there may be a business entity, for example, and that business entity is defunct. It's out of business. It's been dissolved for years. There's a process under our court rule to give notice to that dissolved or defunct business entity. There could be a probate estate. Somebody has died and a personal representative is appointed. There are many different issues to address with service, and service of process is often the most time-consuming aspect of the quiet title action. And that's why I started this presentation by saying that one defendant who's easy to serve makes the lawsuit go much faster versus many defendants, many undischarged interests. After that lawsuit has been served upon all of the defendants, that big net that we've cast in that lawsuit, they have time to respond, to answer. They have an opportunity to defend in the lawsuit. Now, in most quiet title actions, these are procedural in nature, and many of our defendants do not respond. In fact, the vast majority do not respond or consent to the relief that's being requested. But there are times that people will defend, file a responsive pleading, and answer to the lawsuit, and then we have to address that defense in proceedings that occur within the court. And assuming that none of them defend, and they all default, we then file a document with the court that says they have failed to respond within an appropriate time, and we want to enter a default. And that default gets served again, and then eventually we get to go in front of the circuit court judge and say, Judge, we have filed a lawsuit. Here are the defendants that we named. Here is how we served each of those defendants. We have given good notice under Michigan law or Ohio law, depending on where this is occurring. Nobody has responded within the statutory time frame that they are permitted to do so. We want to enter a default judgment, a judgment that resolves the title issue. Now, this would only occur when there's a default scenario. In the scenario upon which defendants have responded or answered, we may have to file motions, what we call dispositive motions. These are motions saying, Judge, we have the right to the ownership of this property. Even though they defended the lawsuit, their defense is meritless. Our plaintiff in our lawsuit has the absolute right to title. So we may proceed various ways with the court to get a judgment. And then when we've got that judgment, that document gets served again. We give the opportunity for the statutory appeal period to expire before we have what we call a perfected judgment. And that judgment would get recorded in the Register of Deeds, just like a mortgage, just like a deed or any other documents that are recorded. And if done correctly, and I'm going to repeat, if done correctly, that judgment will clean or quiet the title. Perfect title in the plaintiff's name. Now, I can't tell you how often my office gets called in which a judgment got recorded by another law firm, or another law firm began the process and then they need us to come in and fix it. The lawsuit and the judgment is only as good as the quality of the work that I just described. So when we hand this document over to a title company down the road, they're going to look at all the work we did before to make sure that we followed the laws and that we afforded due process and we did everything right. Because if you get a judgment and the work done behind it is not correct, it is suspect and subject to be turned over by a subsequent court. So it's critical that you do all the steps correctly. Now, to the question of timing, often we can do quiet title actions in 90, 120 days, but there's no perfect answer to that because we're dependent on the judge's schedule. We're dependent on the number of defendants. And there's no one answer to it because it's not as if we start it and a clock starts ticking and then upon the clock ending, the lawsuit comes to a close. So each quiet title action is its own lawsuit. It's not like a factory where we stamp out lawsuits. Each one has its own story, its own issues, and each one has its own time frame. We tend to quote people about 120 days just to give a rough idea. And the lawsuit, if we're dealing with a tax reversion or a very procedural action, we often will quote a flat fee of $1,400 plus costs. On more complicated matters, we may charge different fees. If you've got questions or want to learn more or have specific issues you'd like me to address in videos, please let me know. Contact us at our law firm at 877-YOUR-FIRM or through quiettitle.com. I'm Darren Findling, and I hope you've enjoyed this presentation. Thank you.